Imagine you own a vintage Rolex Daytona, like a $50,000 masterpiece of engineering,
Mm.
a real family heirloom.
Oh, wow. Okay. Setting the stakes high.
Right. And one day, the second hand starts sticking. So you take it down to this high-end, reputable jeweler in your city just for, a simple battery change and a cleaning.
Makes sense.
They give you a ticket and you walk out.
Ah.
But the next afternoon, some stranger walks into that exact same jewelry shop right off the street.
Okay.
And they see your Rolex sitting there on the counter behind the glass, just waiting to be moved to the safe. The stranger points at it and says, "I want to buy that."
Oh, no.
Yeah. And the jeweler, whether through just like sheer incompetence or maybe absolute malice, they ring it up. The stranger pays, straps your family heirloom to their wrist, and walks out the door.
And let me guess, you come back to pick it up and it's just gone.
It is entirely gone. And here's the truly terrifying part. According to the law, that stranger legally gets to keep your Rolex.
Yeah, it's rough.
You can't call the police and demand it back from them. You have literally lost your watch forever.
It's honestly one of the most brutal, kind of counterintuitive realities in all of commercial law.
It really is.
Because the law essentially looks at you, the innocent, grieving owner, and basically says, sorry, but the smooth functioning of the marketplace is actually more important than your property rights.
I mean, that concept completely shatters everything we think we know about ownership.
It really does.
So, welcome to today's deep dive. We are so thrilled you're sitting down with us. Today, our mission is to translate a notoriously difficult area of the law, Chapter 9, rights and duties of third parties to the contract into clear, understandable English.
Right, because usually when you study contracts, you're looking at this perfectly closed loop.
Exactly. A two-person game. You make an offer, I accept it.
I promise to pay you, you promise to paint my house. It's clean.
It's binary. We know exactly who is on the hook.
But today, we're ripping that closed loop wide open. We're looking at what happens when the rest of the world gets involved.
And for you listening, let's establish the ultimate goal of this exercise right now.
Yes, definitely. We are aiming this material squarely at your preparation for the multi-state bar examination, the MBE.
Because if you've spent any time with practice questions, you know that third-party scenarios are just heavily tested.
Oh, heavily tested. The examiners use them to create these incredibly convoluted, multi-layered fact patterns.
They really want to see if you can track these invisible legal rights as they bounce from person to person.
Right. So instead of just reading you a list of rules, we're going to look at the underlying economic philosophy behind them.
We're going to expose the traps, the distractors, and those exact moments where, like, a simple promise transforms into a lethal legal weapon.
I love that framing.
So to do that, we're going to follow the natural life cycle of a contract.
Okay, where do we start?
First, we'll look at deals where a third party is written into the DNA of the agreement from day one. Intended beneficiaries.
Right, the invited guests.
Then we'll look at what happens maybe 6 months down the line when the original parties get bored or broke and decide to swap someone else into their shoes. Assignments and delegations.
And finally, we'll return to that Rolex scenario.
Yes, the ultimate wild card. The Uniform Commercial Code and what happens when people start selling things they don't even own.
It's a lot of ground to cover.
It is. So let's start from the very beginning of a contract's life.
Okay.
Party A and Party B sit down at a table to make a deal. But they designed this deal specifically to benefit Party C, who isn't even in the room.
Right, so this is the realm of the third-party beneficiary.
Yes.
And the very first hurdle you have to, the absolute dividing line in the law is determining whether Party C is an intended beneficiary or merely an incidental beneficiary.
Okay, let's unpack this, because that distinction is everything, right?
It is everything, because intended beneficiaries have the power to sue, and incidental beneficiaries have absolutely nothing. Zero power.
I want to move away from the generic textbook examples for a second. Let's look at something with massive stakes.
I'm all for it. Lay it on me.
Let's imagine a colossal municipal contract. The city of Chicago signs a $500 million agreement with this mega developer to build a massive new subway terminal in a struggling neighborhood.
Okay, huge project.
Massive. Now, let's say there is a local resident, Maria, who owns a small, kind of struggling coffee shop right across the street from the proposed terminal.
I see where this is going.
Maria hears about this contract, and she realizes the foot traffic is going to make her a millionaire.
Obviously. She's going to get all those commuters.
Exactly. So she goes to the bank, takes out a massive loan, and completely renovates her shop.
Risky but logical.
But then 6 months later, the developer breaches the contract. They just back out, the terminal is canceled, and Maria is left facing bankruptcy.
Oh, that's devastating.
So the question is, can Maria sue the developer for breaching their contract with the city? I mean, she clearly benefited from the deal, right?
She definitely stood to benefit, but she cannot sue. Maria is the textbook definition of an incidental beneficiary.
Wait, really? Even though she took out a loan based on their public contract?
Even then. The law is incredibly strict about this because think about it. If incidental beneficiaries could sue, every single public works project or large corporate contract would be crushed.
Crushed? Under what?
Under the weight of thousands of unpredictable lawsuits from random bystanders. If the city repaves a road and the contractor quits, every homeowner on the street can't suddenly sue the contractor.
Oh, wow. Okay, that actually makes total sense when you scale it up.
Right.
So how does the court systematically prove that she is just a bystander? Because intent feels so invisible.
It does feel invisible, but the courts use a very rigid 4-part test. And for you listening, this is your first major structural pillar for the MBE.
Let's hear it.
You look at the contract between the city and the developer and ask 4 questions. 1, is Maria expressly named or clearly identified in the contract?
No, she's just a local business owner across the street.
Yes, exactly. 2, is the performance, the building of the terminal, being rendered directly to Maria?
No, it's being rendered to the city on city land.
Right. 3, does Maria have any rights to specify details of the performance? Like, can she tell them what color to paint the terminal?
Absolutely not. They would laugh her out of the room.
Exactly. And 4, is there a close relationship between the city and Maria that suggests the city's primary goal in spending $500 million was to make Maria rich?
Definitely not.
Yeah.
The city did it for public infrastructure.
Right. Maria just got lucky. So she fails all 4 parts. She is an incidental beneficiary, meaning she has 0 legal standing to enforce that contract.
It seems like the distinction hinges entirely on whether the original parties deliberately engineered the contract to create a legal weapon for that third party.
That is a perfect way to put it. They have to engineer that weapon.
So how do we tweak the facts to actually give Maria that weapon?
Okay, let's play with the hypothetical.
What if the city had a prior legal settlement with Maria over, let's say, a zoning dispute?
Oh.
And to settle it, they explicitly wrote into the subway contract, the developer shall construct a specialized private access tunnel directly connecting the terminal to Maria's coffee shop, built to Maria's exact architectural specifications.
Ah, now you have completely flipped the legal reality.
Really? Just with that clause?
Just with that clause, let's
Yeah.
run the test again. Is she identified?
Yes, she's named.
Is performance rendered directly to her?
Yes, the tunnel physically connects to her property.
Can she specify details?
Yes, her architectural specs are literally required.
Is there a relationship suggesting intent?
Yes, the city is actively satisfying a prior settlement debt.
Boom. By tweaking those facts, Maria is now an intended beneficiary. If a developer bails on the tunnel, Maria can hire a lawyer and sue the developer directly for breach of contract.
That is fascinating. The law essentially allows the original parties to magically confer legal standing onto an outsider, just by the specific language they use.
That's the power of contracts.
Now, our source material breaks these intended beneficiaries down even further into 2 distinct camps.
Right, creditor beneficiaries and dunda beneficiaries.
Yeah. Why does the law care why the city's building the tunnel? I mean, if she's an intended beneficiary, she can sue? Why split hairs?
Because the underlying motivation changes who the third party is allowed to sue when things go entirely wrong.
Oh, I see.
Let's look at the mechanics of the creditor beneficiary first. A creditor beneficiary exists when the promise, the person demanding the performance, is using the contract to pay off a pre-existing debt they owe to the third party.
So in our modified scenario, the city owed Maria a debt from that zoning settlement.
Exactly.
The city is the promisee. They demand the developer, the promiser, build the tunnel to pay off that debt. That makes Maria a creditor beneficiary.
You got it. The contract is purely a vehicle for discharging a past obligation.
Okay, so contrast that with a Donnie beneficiary.
Right. Donnie shares a root with donation. In this scenario, the promise owes the third party absolutely nothing. The purpose of the contract is purely to confer a gift.
Let's ground that one too. Let's say a billionaire tech founder, Marcus.
Okay, Marcus.
He wants to do something nice for his niece, Chloe, who just graduated college.
Nice guy.
Yeah. So Marcus signs a contract with a luxury car dealership. He pays them $100,000 in cash.
Wow.
And the dealership promises to deliver a custom sports car directly to Chloe's driveway on Saturday.
Yeah.
Marcus doesn't owe Chloe a car. It's just a pure gift.
So in that case, Chloe is the Dunane beneficiary.
Right.
And here is where we hit what the examiners consider the holy grail of third-party contract law.
The Holy Grail.
Yes, the concept of vesting.
Vesting. It's a great word. It sounds like putting on armor.
That's exactly what it is. It is the exact moment when Chloe's right to that sports car transforms from a flimsy, revocable promise into an ironclad, enforceable property right.
Why is vesting so critical, though? What happens before the armor goes on?
Well, before a third party's rights vest, the original parties, Marcus and the dealership, are the absolute masters of the universe.
Yeah, maybe they could do whatever they want.
Exactly. If Marcus wakes up on Friday morning, realizes Chloe got a terrible job, and decides to cancel the gift, he can just call the dealership, rip up the contract, and get his money back.
And Chloe has no say in the matter.
None. Even if she is an intended beneficiary, before vesting, she is completely powerless to stop them from modifying or destroying the agreement.
But the nanosecond those rights vest.
The trap snaps shut. The moment Chloe's rights vest, Marcus and the dealership lose their power to alter the deal without her explicit consent. They are locked in.
I can completely see how this becomes a playground for the bar examiners.
Oh, they love it.
They're going to give us a timeline. Right. Like
Yeah.
Monday, Marcus buys the car. Wednesday, Chloe does something. Friday, Marcus tries to cancel.
Exactly. The entire legal outcome depends entirely on what happened on Wednesday.
So what actually triggers this armor? How does a right vest?
There are 3 specific triggers, and you need to have them memorized cold for the MBE.
All right, lay them out.
Trigger number 1. The beneficiary manifests assent to the contract in a manner invited or requested by the parties.
Meaning she just agrees to it?
Yes, but it has to be communicated. If Marcus calls Chloe and says, hey, I bought you a car, the dealership is bringing it Saturday, and Chloe says, oh my gosh, thank you, I accept. Boom.
Her rights just vested.
Yes. By manifesting her assent, she locked the contract in place. Marcus cannot call the dealership an hour later and cancel it.
What if she doesn't find out from Marcus? What if she just randomly decides to sue the dealership because they're late delivering it?
That brings us to trigger number 2. A beneficiary's rights vest the moment they bring a lawsuit to enforce the promise.
Wait, really? Just filing a lawsuit locks it in?
The act of filing the complaint in court is the ultimate manifestation of claiming the right. So if the dealership is late and Chloe files a lawsuit, Marcus can no longer call the dealership and try to quietly settle the matter and cancel the car. The lawsuit locks the door.
Okay, those first 2 are pretty straightforward. Assent and lawsuits. But what about the third trigger?
The third trigger is the most heavily tested, the most philosophically rich, and the most fact-dependent.
Okay.
Detrimental reliance. A right vests when the beneficiary materially changes their position in justifiable reliance on the promise.
This feels like one of the most powerful doctrines in all of civil law.
It really is.
Let's explore the mechanics of this with Chloe.
Sure.
Chloe hears she is getting a brand new $100,000 sports car on Saturday.
Right.
Because she believes this, she goes online on Thursday and sells her old, reliable, beat-up Honda Civic for cash.
Oh, okay. Big move.
Yeah, she completely alters her life based on the expectation of this gift.
That is exactly it. Look at the economic reality here. If the law allowed Marcus to cancel the contract on Friday, Chloe would be left completely stranded.
Yeah, she sold her only mode of transportation.
The legal system recognizes that when people make promises, other people arrange their lives around them. So, the moment Chloe sold her Honda, the moment she suffered a financial detriment in reliance on the promise her rights in the sports car vested.
So Marcus and the dealership are now legally barred from canceling the deal.
100% barred.
It's brilliant. It balances the freedom of the original parties to change their minds with the societal need to protect innocent people from having the rug pulled out from under them.
Precisely.
So let's say the rights have vested, the armor is on,
Okay.
but the dealership refuses to deliver the car.
Typical.
Let's look at the litigation phase. Who is allowed to sue whom?
The baseline rule is empowering, but it comes with a massive hidden trap.
And listen,
The intended beneficiary, whether they're a creditor like Maria or a Dunn like Chloe, can always sue the promisor directly.
because the promiser is the one who was supposed to actually do the work or deliver the goods.
Right, so Maria can sue the developer, and Chloe can sue the dealership.
But you said there is a trap.
The trap is that the third party essentially steps directly into the shoes of the promisee. When Chloe sues the dealership gets to use every single legal defense against Chloe that they could have used against Marcus.
Whoa. Wait. So if Marcus's $100,000 check bounced and he defrauded the dealership?
Exactly. The dealership can stand up in court and say, we don't owe Chloe a car because Marcus's check bounced. Lack of consideration, breach of contract.
Oh, I see. Chloe's right to the car is entirely parasitic on the validity of the original contract between Marcus and the dealership.
Parasitic is the perfect word. If the original contract is defective, the third party suffers the consequences.
That is a phenomenal distractor for an exam question. They will write a scenario where the third party detrimentally relies, they sell their old car, they vest, and the student will confidently think, they vested, so they automatically win the lawsuit.
Yep, they fall right into the trap. Because if the promisor has a valid defense against the original guy, the third party loses anyway. You must always check the health of the underlying contract.
Always check the health of the contract. Got it. Now, that covers the third party suing the promisor.
Right.
But what if the third party turns around and wants to sue the promisee? What if Chloe wants to sue her uncle Marcus, or Maria wants to sue the city?
This is where that creditor versus Duren distinction we talked about earlier must come back into play. It's really the only reason the distinction exists.
Okay, let's look at Maria, the creditor beneficiary.
The city owed her a debt from a zoning settlement. They tried to pay it off by having the developer build a tunnel. The developer fails.
Right. Does Maria's original debt from the city just magically evaporate?
No, absolutely not. She can turn right around and sue the city on the original underlying obligation. A creditor beneficiary can always sue the promisee.
That makes total economic sense. The debt wasn't discharged because the tunnel was never built.
Correct.
But wait, can she sue both of them? Can she sue the developer for the tunnel and the city for the settlement cash?
She can sue both simultaneously, yes. But she cannot double dip.
So she can only recover once.
Exactly. The moment she is made whole by either party, the litigation ends. She gets the value of what she was owed, nothing more.
Okay, what about Chloe, the donee beneficiary? The dealership fails to deliver the sports car. Can Chloe sue her uncle Marcus for $100,000?
Think about the philosophy of a gift.
Okay.
The law generally does not enforce naked promises to give a gift because there is no consideration. Chloe didn't pay Marcus for the car.
Right, she gave nothing in return.
So generally, a donee beneficiary cannot sue the promisee if the gift falls through. Marcus was just trying to be nice. He shouldn't be penalized if the dealership ruins it.
Unless she detrimentally relied.
There you go, right.
If she sold her old Honda Civic because Marcus promised her the new car,
Yeah.
and then Marcus maliciously canceled the contract, could she sue him then?
Yes. If there is detrimental reliance, she can sue the promisee under the doctrine of promissory estoppel.
Because she suffered a financial detriment because of his unfulfilled promise.
Exactly. But without that reliance, a pure donee has absolutely no claim against the promisee.
Hearing you lay out the mechanics like that really highlights how unforgiving this area of law is.
Very unforgiving.
If you misidentify the type of beneficiary or miss the moment of vesting, you misapply the entire liability structure.
You'll get the MBE question entirely wrong.
So let's take a breath and just synthesize this real quick.
Good idea.
We just explored the birth of a contract that included a third party from the very beginning. Intended beneficiaries like Maria with her tunnel have rights. Incidental beneficiaries like Maria with her coffee shop foot traffic do not.
Spot on.
We know the difference between paying a debt and giving a gift. And we know that vesting through assent, lawsuits, or alliance is the moment the promise becomes permanent.
And if you can track who can sue whom, keeping in mind that the promisor's defenses travel with the contract, you are fully insulated against the examiner's tricks in this section.
Excellent. So we have seen what happens when you plan for a third party on day one.
Yep.
But human nature is fickle. Circumstances change.
Don't they always?
What happens 6 months down the line when the original two parties are locked in a deal, but suddenly one of them wants out or they need fast cash, and they decide to swap a completely new stranger into their shoes?
This brings us to the messy, high-stakes world of assignments.
To navigate this, we absolutely must establish a firm, unshakable vocabulary, right?
We have to. The bar examiners will aggressively use words like assignor, assignee, and obligor in the exact same sentence just to make your head spin.
If you don't know who is who, you're dead in the water.
You really are.
So let's anchor these terms to a continuous high-stakes hypothetical.
I like it. Let's build one.
Let's say I own a massive tech startup.
Okay. Congratulations.
Thank you. I hire you, an elite software engineering firm, to build a revolutionary new app. I sign a contract promising to pay you $1 million when the app is delivered.
Okay, so you are obligated to pay me. That makes you the obligor.
Right, I'm the obligor. You have the right to receive the $1 million. But halfway through the project, your engineering firm runs into cash flow issues.
Happens to the best of us.
You need money today to make payroll. So you go to an outside investment bank
Right.
and you say, hey, we have the right to receive $1 million from this startup in 3 months. If you give us $900,000 in cash right now, we will transfer our right to receive that future million to you.
That is the perfect scenario. In that transaction, my firm, the engineering firm giving away the right, is the assigner.
The assigner gives.
Exactly. The investment bank receiving the right is the assignee. And your startup, who still just owes the money, remains the obligor.
Okay, now in my head, I signed a contract with you.
Yeah.
I didn't sign a contract with an investment bank. Does the law actually allow you to just sell off your rights to my money behind my back?
The law doesn't just allow it, the law actively encourages it.
Really? What?
The fundamental default rule is the assignable unless rule. Generally speaking, all contract rights are freely assignable. Think about the economic mechanics of this. If you couldn't assign the right to receive money, the entire modern credit system would just collapse.
Oh, because of, like, mortgages and car loans?
Exactly. Corporate debt, credit cards, all of it relies on the ability of lenders to bundle and sell the right to receive future payments. The free alienability of rights creates liquidity in the market.
That makes profound economic sense. If rights couldn't be sold, capital would just be trapped.
Right.
But there have to be limits. You said assignable unless. When does the law step in and say, no, you cannot sell this right?
The primary exception, and the one that generates the most litigation, is when the assignment would substantially change the obligor's duty or risk. This almost always involves personal services or highly specialized skills.
Right, so if assigning the right to money is risk-free for me, I mean, writing a check to an investment bank requires the exact same effort as writing a check to you. What happens if we flip the roles?
Let's flip them.
What if I hired a world-class, 3-Michelin-star chef to cater my daughter's wedding?
Okay.
The chef can't suddenly assign his right to cook the meal to a guy who runs a local fast food franchise, right?
Exactly, because you bargained for the unique, irreplaceable skill of that specific chef. Having a fast food cook show up radically alters the nature of what you are receiving. It fundamentally changes your risk.
So the right to perform highly personal services is never assignable without consent.
Never.
What about the contract language itself? Because corporate lawyers are paranoid.
They are very paranoid.
If I am the tech startup and I don't want you dealing with investment banks, can I just write a clause into our contract that says no assignments?
You can, but you are walking straight into one of the most notoriously tricky interpretation traps in all of contract law.
Oh, really?
Oh, yeah. Let's say your lawyer drafts a generic clause that says, there shall be no assignment of the contract. How do you think a court interprets that?
I mean, I would assume it means nobody can assign anything. No rights, no duties, nothing. The contract is locked.
That is what most people assume, and that is why they fail the MBE question. Because the law so heavily favors the free transfer of property, courts interpret that vague language incredibly narrowly.
Oh, narrow.
If the contract just says no assignment of the contract, courts will rule that it only prohibits you from delegating your duties, the actual software coding, to someone else. It does not prohibit you from assigning your right to get paid.
Wow. Wait, really? So even with that clause, you could still sell the right to the $1 million to the investment bank?
Yes. If you want to block the transfer of money, you have to be excruciatingly specific. You have to write, the right to receive payment under this contract is strictly non-assignable.
And does that work?
Well, even then, under the UCC, if it involves the sale of goods or accounts receivable, the law might override your clause anyway just to keep commerce flowing.
That's wild.
But for the common law MBE, remember, generic no assignment clauses only block duties, not rights.
Okay, so let's say the assignment is valid. You sold the right to the $1 million to the investment bank.
Right.
But then your firm lands a massive new client the next day. You are flush with cash. You decide you don't need the investment bank's money anymore, and you want to keep the full $1 million for yourself.
Changing my mind.
Yeah. Can you just call the bank and say, never mind, the assignment is revoked?
This depends entirely on the nature of the transaction. The law aggressively distinguishes between an assignment for value and a gratuitous assignment.
Value versus gratuitous?
Exactly. It's the difference between a hard-nosed business deal and a simple gift.
Well, in our scenario, the investment bank paid you $900,000 in cash for the assignment. That is clearly value.
And because value is exchanged, the rule is absolute. An assignment for value is completely irrevocable.
Irrevocable.
Once you take the bank's money, or even use the assignment to secure a pre-existing loan, the deal is permanent. You cannot take it back.
Well, what if it wasn't a business deal? What if, instead of an investment bank, you just assigned the $1 million to your adult daughter as a graduation gift?
Okay, a nice gift.
Yeah, you didn't get any money in return. That is a gratuitous assignment.
Gratuitous assignments are fragile. Because you received no consideration, the law generally allows you to change your mind. You can revoke a gift assignment the very next day.
Just like that.
Just like that. However, there are 4 major exceptions where even a gift assignment becomes permanently locked in irrevocable.
Let's hear them. How does a gift become permanent?
First, if the obliger, the startup, has already performed.
So if I already paid her.
Exactly. If the startup already wired the $1 million to your daughter's bank account, it is too late for you to revoke it.
Makes sense.
Second, if there is a signed writing. In many jurisdictions, if you put the gift assignment in a formal signed document, it becomes irrevocable.
Okay, what's the third?
Third is our old friend detrimental reliance. If your daughter went out and bought a mansion because she relied on your promise of $1 million, you are stopped from revoking it.
Reliance is everywhere. It's like the gravity that holds contract law together.
It really is.
What is the fourth exception?
The fourth is the delivery of what the law calls a token chose.
A token chose. That sounds ancient.
It is ancient. It refers to a physical, tangible object that symbolizes the intangible right.
Like,
Think of a physical stock certificate, a life insurance policy document, or a passbook for a savings account. If you physically hand your daughter the actual embossed stock certificate that represents the value, the physical delivery of that token makes the gift irrevocable.
that makes sense. It is the physical manifestation of transferring power.
Exactly.
Okay, so let's move to the real drama. The post-assignment reality.
Okay, let's get into it.
The assignment to the investment bank is valid. It was for value. It is irrevocable. Now look at me. I am the obliger, the tech startup. I have my $1 million ready. The app is done. Who do I pay?
You must pay the new assignee. You must pay the investment bank. But, and this is the hinge upon which every single assignment MBE question turns, you only have to pay the bank after you've been properly notified of the assignment.
Notice. Let's explore the mechanics of notice.
Sure.
Because if you and the investment bank sign this deal in a boardroom, but neither of you ever bothers to send me an email or call me to tell me about it, I am just sitting in the dark.
And because you are in the dark, the law protects you entirely.
So if I pay you,
If you have no notice of the assignment and you pay the original signer, you pay the engineering firm, your contractual obligation is completely discharged. You are free and clear.
and the investment bank,
The investment bank cannot come knocking on your door demanding a second $1 million. Their only recourse is to sue the engineering firm for taking money that didn't belong to them.
But what if the investment bank is smart? What if they send me a certified letter on their heavy corporate letterhead explicitly stating, "We are the new assignees of this contract. You must direct all future payments to our account."
Okay, so you have notice.
Yes, I receive it, I read it, but
Oh.
my accounting department is lazy,
Mm.
and we just process the payment to the engineering firm out of habit anyway.
Then your startup has made a catastrophic $1 million mistake.
Uh-oh.
The law says that once the obliger is on notice, performance to the assignor is at the obliger's own risk. Because you paid the wrong person after being warned, the investment bank will sue you and they will win.
Wait, I'll have to pay twice.
Yes. You will be legally forced to pay a second $1 million to the bank, and then you will have to try to sue the engineering firm to get your original payment back. Notice redirects the mandatory flow of performance.
That is a harsh, unforgiving rule.
But it is necessary to make the system work.
Now, what about the relationship between you, the assigner, and the investment bank? If you sell them this right for $900,000, what are you actually guaranteeing them? The outline mentions implied warranties.
This is a brilliant area of law because it shows the courts acting to protect the integrity of the secondary market.
Okay.
When you assign a right for value, the law automatically implies 3 warranties into the transaction, even if they aren't written in the contract. First, you warrant that the right actually exists and is not subject to any undisclosed offenses.
So, if secretly your engineering firm used stolen code, and you know my startup is going to refuse to pay the $1 million because of a massive copyright breach,
Right.
you can't just sell that defective right to the bank to offload your problem.
Exactly. If you sell them a worthless, defective right, you have breached that implied warranty, and the bank can sue you for fraud.
Makes sense. What's the second?
Second, you warrant that you haven't already assigned this right to someone else.
Okay, logical.
And third, you warrant that you will do nothing to interfere with the right after the fact. You won't try to secretly collect the money from the startup yourself.
Which brings us perfectly to the shady assigner scenario.
Yeah.
Let's talk about successive assignments.
Oh, this is a fun one.
What if you violate that second warranty? What if your engineering firm is completely desperate and fraudulent?
Let's assume the worst.
On Monday, you assign the right to the $1 million to investment bank A for cash.
Okay.
On Tuesday, you go across town and assign the exact same right to investment bank B for cash. On Wednesday, you assign it to bank C.
Wow.
You are just monetizing the same asset over and over. How does the law sort out this mess? When the startup finally writes the check, who gets the $1 million?
It is the ultimate law school puzzle. But the general rule is actually very clean. First in time, first in right.
First in time, first in right.
Yes, the first irrevocable assignment wins. So, investment bank A, who took the assignment on Monday for value, has priority. They get the $1 million from the startup.
And the other banks.
Bank B and Bank C get absolutely nothing from the startup. They are just left holding breach of warranty claims against your fraudulent engineering firm.
But are there exceptions? Could Bank B, who was second in line, ever somehow jump over Bank A and claim the money?
Yes, there are a few narrow exceptions where a subsequent assignee can win,
Let's hear them.
but they require the subsequent assignee to take the assignment in good faith for value and without any knowledge of the earlier assignment.
So Bank B has to be innocent.
Yes. If Bank B is innocent, they can win if they are the first to get a formal judgment against the startup in court.
Oh, a race to the courthouse.
Exactly. Or if they are the first to actually receive the payment from the startup. Or if they receive that physical token shows we discussed.
So essentially, if the second innocent bank manages to finalize the physical collection process before the first bank even realizes what happened, the law will sometimes let the reality on the ground stand.
Yes, reality on the ground can win. But the default rule you must carry into the exam room is the first irrevocable assignment wins.
That is a phenomenal breakdown. We have covered the transfer of benefits, but let's shift to the darker side of the coin, passing the buck.
Ah, the delegation of duties.
This is a crucial transition. Assigning is about giving away your rights, the good stuff, the money, the rewards. But what if you want to give away your obligations? What if you want to hand off the actual hard labor to someone else?
This is a delegation, and just like with assignments, we need to lock in the terminology so you don't get lost in the exam questions.
Okay, let's lay it out.
The original party who is transferring the workload is the delegator. The third person stepping in to do the work is the delegate. And the person sitting there, waiting for the work to be finished, is the obligee.
Let's escalate the stakes again. Let's say I am the mayor of a city. I'm the obligee. I sign a contract with you, the owner of a massive, renowned steel manufacturing company, to build the main suspension cables for a new bridge.
Okay, so I am the delegator.
Right. But your factories get overbooked. So you decide to delegate the duty of forging these cables to a smaller pop-up foundry that just opened last week. They are the delegate.
Got it.
Now, earlier you said almost all rights are freely assignable. Is it the same for duties? Can you always just pass the buck?
The baseline presumption is, yes, duties are generally delegable, but the exceptions are vastly more restrictive here because the economic reality is different.
How so?
When you are owed money, you generally don't care whose name is on the check as long as it clears. But when you are owed a service, especially a complex or dangerous one, you care deeply about who is performing the work.
So when is delegation absolutely prohibited?
The first and most obvious exception is when the duty involves personal judgment, artistic skill, or a highly specialized ability.
Like the world-class chef.
Exactly. You can't delegate an artistic portrait to an apprentice. The second exception is when there is a relationship of special trust and confidence. Think of the fiduciary duties of a doctor or a lawyer.
Right. My brilliant trial attorney cannot just delegate my murder defense to a random law student without my explicit permission.
Precisely. That duty is non-delegable.
That makes perfect sense. But what about our suspension bridge? Manufacturing steel cables is highly technical, but it's an industrial process, not an artistic portrait. Does that fall under an exception?
That brings up the third exception. A duty cannot be delegated if the delegation would materially change the obligee's expectancy under the contract.
Materially change the expectancy.
Yes. Building suspension cables requires massive quality control and proven metallurgical expertise. If you delegate that to an unproven pop-up foundry, the city's risk of a catastrophic bridge failure skyrockets.
So the nature of what they bargained for, reliability and proven safety, has been materially altered.
Exactly. A court would almost certainly rule that duty non-delegable.
And the fourth exception is just the contract language itself, right?
Yes, and unlike assignment clauses, courts strictly enforce anti-delegation clauses. If the contract says no delegation of duties, you are locked in, period.
Okay, let's assume for a moment the duty is something routine and delegable.
Okay.
Let's say instead of the bridge, it's just a municipal contract to mow the grass in all the city parks. You delegate the mowing to your friend's landscaping company.
A simple delegation.
Right. Now here is a question, and I feel like this is the single biggest trap in the entire chapter.
Let's hear it.
If you delegate the mowing to your friend, and your friend does a terrible job or just fails to show up,
Yeah.
you are off the hook, right? You pass the buck. The city has to sue your friend.
I emphatically, violently correct that assumption.
Wow, okay.
If you take nothing else away from this discussion, remember this: the delegator remains liable.
Really?
You are never, ever fully released from your contractual obligations just by handing the work to someone else. This is the golden rule of delegation, and it is tested constantly.
Even though I legally assign the work to my friend, the city can still sue me.
Absolutely. The law views the delegator as having secondary liability. You act almost like a surety or a guarantor for your delegate.
A guarantor.
When you signed that contract with the city, you made a legal promise that the grass would be mowed. The fact that you hired someone else to push the lawnmower doesn't erase your promise. If your friend fails, you have breached your contract with the city. The city can come straight after you for damages.
That is a staggering realization. It means you can't just shed your liabilities by passing them to an incompetent third party.
No, you cannot.
But what about the friend? What about the delegate? Can the city sue the friend who actually failed to do the work?
That depends entirely on whether the delegate legally assumed the duty.
Assumed the duty.
Yes, this is a very specific mechanical concept. A delegate is only liable to the original obligé, the city, if they specifically promise to perform the work, and that promise was supported by consideration.
So if you just casually asked your friend as a favor, hey, could you mow these parks for me this weekend? And he said, sure, I'll try. He hasn't assumed legal liability.
Correct. He just made a gratuitous promise. If he bails, the city can only sue you.
But what if you offered to pay your friend $50,000 of your city contract money to take over the mowing, and he signed a contract with you agreeing to do it?
Now he has formally assumed the duty. And when a delegate assumes a duty for consideration, something legally magical happens. It ties this entire deep dive together.
Oh, I like the sound of that.
When your friend promises you he will mow the city's grass in exchange for money, the city suddenly becomes a third-party beneficiary of the agreement between you and your friend.
Oh, wow. We just completed the loop. We are right back where we started with intended beneficiaries.
Exactly. Because you paid your friend to perform a service that discharges your obligation to the city is now an intended creditor beneficiary of your new deal.
Which means, as we learned an hour ago, the city can sue the promisor directly. The city can sue your friend.
Yes. And because of the golden rule of delegation, the city can also still sue you.
The elegance of how these doctrines interlock is incredible.
It's beautiful in a terrifying way.
So, to summarize the friction of delegation, you can usually hand off the work, but you can never hand off the liability.
Exactly.
Which immediately begs the question, how do you actually escape? If delegation leaves me secondarily liable as a guarantor, how do I achieve a clean break? How do I walk away from a contract forever without the fear of being sued?
To achieve a true clean break, you need a novation.
A novation.
Yes, a novation is the ultimate contractual reset button. It is a brand new agreement that completely replaces the old one, extinguishing the original obligations entirely. But to achieve it, you need the Holy Trinity of consent.
The Holy Trinity of consent, what does that require?
It requires that all three parties, the original delegator, the new delegate, and the original obligé, must explicitly and unequivocally agree to substitute the new party and completely release the original party from any and all future liability.
So if we go back to the park mowing contract, you want out. You don't want to just delegate to your friend and risk being sued if he breaks a mower. You want a novation. What has to physically happen?
The three of us, you, your friend, and the mayor, have to sit down and sign a document that explicitly states three things.
Okay.
1, Your friend agrees to take over the mowing. 2, the mayor agrees to accept your friend's services instead of yours. And 3, this is the critical, indispensable element. The mayor explicitly agrees to completely discharge and release you from any liability if things go wrong.
And if you don't get that explicit
If
release,
you do not secure that explicit release, it is not a novation. It is just a delegation, and you are still on the hook.
I can see the MBE trap forming right now. The examiners will give a scenario where the mayor says, sure, your friend can do the mowing, that sounds fine. And the question will ask, is this a novation or a delegation?
And the answer is always delegation. On the exam, you must ruthlessly hunt for the consent of everyone to a complete release. A grunt of approval, a nod, or saying, that's fine, is not a release of liability.
Novation equals complete discharge. Delegation equals original party remains a surety.
They will try to blur the lines, but you must demand clear evidence of the Holy Trinity.
That is incredibly clarifying. So we have explored the common law of contracts. We've dealt with services, debts, software, and bridges. We are now going to shift gears for our final act.
Okay, let's do it.
We are leaving the common law and entering the domain of the Uniform Commercial Code, the UCC, which deals exclusively with the sale of physical goods. This brings us right back to our opening scenario with the Rolex watch. The outline refers to this as the power of a non-owner to transfer good title.
Right. This area of law represents a massive philosophical collision between traditional property law and modern commercial law.
It seems like it.
The central tension is agonizingly simple. When an innocent person's property is wrongfully sold to another innocent person, who wins? Do we protect the original innocent owner, or do we protect the innocent buyer who purchased the good in the open market?
Let's finally resolve the Rolex scenario.
Yep.
This is the doctrine of entrusting to a merchant. Walk me through the mechanics of why I lost my watch.
The UCC rule states, if an owner entrusts goods to a merchant who deals in goods of that kind, the merchant has the power, though absolutely not the legal right, to transfer all rights of the entruster to a buyer in the ordinary course of business.
Let's break that down. First, the entrusting. I dropped my watch off for a battery change. That qualifies as entrusting.
Yes. Entrusting includes any delivery and any acquiescence in retention. Leaving it for repair, leaving it for appraisal, storing it, it is all entrusting.
Okay. And the jeweler is a merchant who deals in goods of that kind. They sell watches. So they have the power to transfer title. When that stranger walked in off the street and bought it from the display case, they were a buyer in the ordinary course of business.
Exactly. They didn't know it was stolen. They just bought it like a normal retail customer.
And because all those elements were met, the UCC dictates that the stranger receives perfect, unassailable title to your Rolex. The law actively strips you of your ownership and grants it to the buyer.
You cannot replevy the watch. Your only legal remedy is to turn around and sue the jeweler for the monetary value of the watch, assuming they haven't gone bankrupt or fled the country.
Why? I mean, why would the law sanction what essentially feels like legalized theft by proxy? Why is the UCC so aggressive in protecting the random buyer over the true owner?
Because the drafters of the UCC were looking at the macroeconomic picture. They realized that the velocity of commerce, the smooth, rapid buying and selling of goods, is the lifeblood of the economy.
Okay.
If a customer walks into a jewelry store or a car dealership or an electronics shop, the law wants them to feel absolute 100% confidence that if they pay for an item, it is theirs. Imagine if the law favored the original owner. Every time you bought a used watch or a refurbished laptop, you would live in fear that 6 months later, a stranger could knock on your door with a court order claiming the shop didn't have the right to sell it to you.
You would have to hire a private investigator to trace the title of every single item you bought.
Exactly. Commerce would just grind to a halt due to friction and paranoia.
So the law is making a cold, calculated utilitarian choice. It sacrifices the occasional unlucky owner to ensure that the millions of daily retail transactions happen without hesitation. The burden falls on the owner to choose a trustworthy merchant.
Exactly. You chose the merchant, you introduced the risk, the random buyer walking in off the street had no way to know. The law protects the marketplace over the individual.
That is a harsh reality. Now, the outline contrasts that entrusting rule with two other scenarios involving bad actors, voidable title and the thief rule. Let's look at voidable title first. This involves fraud.
Let's hear the scenario.
Let's say I put my car up for sale online. A guy comes to my house, seems very professional, and writes me a cashier's check for $20,000. I hand him the keys and the title. He drives away.
Okay.
3 days later, my bank calls. The check was a sophisticated forgery. It bounces. I have been defrauded.
You have been. And because the fraudster obtained the car through deceit, he holds what the law calls voidable title.
What does that mean?
This means that as long as he still has the car, you have the absolute right to void the transaction, call the police, and get your car back.
But the fraudster is fast. Before I realize the check bounced, he drives one state over and sells my car to an innocent college student for $15,000 cash.
Of course he does.
The student has no idea it's stolen. They just think they found a great deal on a used car.
The student is what we call a good faith purchaser for value. And the rule for voidable title states that a person with voidable title can transfer good, unassailable title to a good faith purchaser.
Wait, really?
Yes. The moment the student buys the car, your right to void the transaction is permanently cut off. The student keeps the car, you lose, and you have to try to hunt down the fraudster.
So once again, the innocent buyer wins and the original owner loses.
That's the pattern.
But let's contrast this with the final scenario, the thief rule. Let's change the facts. Nobody writes me a bad check. I am just sleeping in my house. A thief breaks my garage window, hotwires my car, and steals it in the dead of night.
A literal physical theft.
Right. The next morning, that thief drives one state over and sells the car to the exact same innocent college student for $15,000 cash. What happens now?
This is where the law finally crosses the line. A thief who physically steals an item does not have voidable title. They have void title,
Void title.
which is to say they have no title at all. The thief rule dictates that a thief generally cannot pass good title to anyone, ever, even to a completely innocent good faith purchaser.
So if I track down the car, I can take it back from the college student.
Yes. In the case of outright theft, the original owner wins. You get your car back, and the innocent student is the one left empty-handed, forced to try and sue the thief who is already long gone.
I want to pause and really explore the philosophy behind this distinction because it is the key to remembering it for the MBE.
It really is.
Why does the innocent buyer win in the fraud scenario but lose in the theft scenario? I mean, to the college student, the situation looks exactly the same. They paid cash to a guy for a car.
It comes down to the legal concept of volition and the economic theory of the least cost avoider.
Least cost avoider. Who is in the best position to prevent the loss?
Exactly. In the fraud scenario, you willingly, voluntarily handed over the keys and the title. Yes, you were tricked, but you participated in the transaction.
I could have waited for the check to clear. I could have demanded a wire transfer.
Right. Because you voluntarily introduced the car into the stream of commerce. The law says you bear the risk if things go wrong, not the blind third-party buyer.
But in the theft scenario,
In the theft scenario, you did absolutely nothing wrong. You didn't participate in a transaction. The item was ripped from you by force. You were not the least cost avoider. You were entirely a victim.
because I lacked volition.
Exactly. Because you lacked volition, the law refuses to punish you to protect the marketplace. The true owner's rights are preserved against the entire world.
Fraud implies participation. Theft implies violation. That makes perfect sense.
It's a great way to remember it.
Let's do a quick mechanical recap of these 3 UCC title rules because they are guaranteed points on the exam.
Let's do it.
1. The entrusting rule. If you leave your property with a merchant who deals in those goods, they have the power to sell it to an innocent buyer, and you lose.
Correct.
2. Voidable title. If you are tricked by a fraudster into handing over your property and they sell it to an innocent buyer, you lose.
Yep.
3. The thief rule. If your property is physically stolen and sold to an innocent buyer, you win. You can always recover stolen goods.
That is the precise mental framework you need. If you spot the mechanism of how the property left the owner's hands, entrusting, fraud, or theft, you immediately know who wins the lawsuit.
We have covered an immense landscape of legal architecture today. We have moved from the meticulous planning of intended beneficiaries through the high finance world of assignments into the murky surety of delegations and finally into the brutal, market-driven realities of the UCC. As we wrap up, I want to ask you to provide one final cohesive synthesis of Chapter 9.
Think of Chapter 9 not as a list of disconnected rules, but as a map of risk.
A map of risk.
When a third party enters a contract, risk shifts. With beneficiaries, the risk shifts to the original parties the moment the third party vests through reliance or assent.
Right.
With assignments, the risk shifts to the obligor the moment they receive explicit notice. With delegations, the risk remains anchored to the delegator, keeping them on the hook as a surety unless they secure the holy grail of innovation.
And with the sale of goods.
The UCC shifts the risk of fraud and entrusting away from the marketplace and squarely onto the shoulders of the original owner. If you follow the risk, you will find the right answer.
It really is a delicate, continuous balancing act between the freedom of contract, the protection of innocent reliance, and the sheer economic necessity of keeping commerce flowing without friction.
It absolutely is.
Which brings us to our final thought for the day.
I want to leave you with something to ponder that takes the rigid rules of the UCC and applies them to the reality we live in right now.
Okay.
Think about the philosophical justification for the entrusting rule and voidable title. The idea that protecting the smooth flow of commerce is more important than protecting the original owner.
Right, to keep the retail economy moving.
The drafters of the UCC made this decision in the mid-20th century, imagining physical jewelry stores and car lots. But today, we live in a digital economy.
Very true.
We are constantly buying used, refurbished, or secondhand goods online from massive, faceless platforms and third-party merchants we will never meet. The velocity of commerce is 1,000 times faster than it was when these rules were written.
So the risk is magnified.
Exactly. As you go about your week, ask yourself, in an era where a stolen good can be sold globally with the click of a button, does prioritizing the good faith purchaser still create trust in our economic system? Or does it inadvertently create a massive incentive for digital fraud, knowing that once an item hits the secondary market, it is practically untouchable?
That is a phenomenal question. It highlights how these deeply historical, mechanical, legal principles are currently struggling to map on the anxieties of our modern, hyper-connected economy. Thank you so much for joining us on this deep dive. We hope this exploration of Chapter 9 has brought clarity to the chaos of third-party rights, and we wish you the absolute best in your continuing legal studies. Keep questioning the rules, keep tracing the risk, and we will catch you next time.